I heard from, oh, never mind. We gonna have any parents with us today?
No, Your Honor.
No, Your Honor. Judge, my client filed a waiver of interest in this case, so you won't be appearing today.
Mr.
McKesson, would you please begin the announcements?
Yes, Judge Straight McKeska, attorney for the department.
Christy Cannot, permanency supervisor with Belong.
Ontropolis, permanency specialist with Belong.
Jennifer Harris, attorney for the respondent mother. I'm announcing not ready, Your Honor. I've had no contact with my client.
Kathleen Savage for Joshua Penner, the presumed father. Not ready, Your Honor. No contact.
Richard Saldivar, attorney for the alleged father, Michael Rodriguez. Ready, Judge.
Irene Acosta for the child. I'm ready, Judge.
Jill Roden, Tri-County Costa.
All truth and nothing but the truth.
Yes, sir.
Thank you. We've got not ready announcements. Ms. Harris and Ms. Savage on behalf of Ms. Gomez and Mr. Pinner. We are set for final trial with a dismissal date of September 16th. And I do show and I'm aware that Ms. Gomez was personally served almost a year ago, September 20th of 23. And Mr. Pinner, we had some issue with service on him. And just for the purpose of the record, where do we stand with Mr. Pinner, Mr. McKesson?
Yes, Judge. So Mr. Pinner was personally served on August 16th of 2024. The Williamson County Constable did send, or they told us that they mailed the citation back to the clerk. Clerk hadn't received it, so Ms. Ortiz did reach out to the constable yesterday. They provided a copy of their affidavit, and that was filed with the district clerk yesterday afternoon. I don't know if it's been accepted yet, but based off the date of service for Mr. Pinner, the answer date doesn't run until September 9th of 2024. So I would like to, at least with regard to him, push trial back to the September 10th docket. I know that's a long docket. It'd be, late into the afternoon. But that way there wouldn't be any sort of service or jurisdictional issues with regard to him.
All right. And then are you going to proceed as to the mother today or just do it all at once?
I would leave that to the court's discretion, Judge. I mean, I am prepared to move forward with regard to Ms. Gomez and Mr. Rodriguez today. But if you just want to hear everything at once, so we're not having to split the baby, then we can do that as well.
I think since we have the time, I'm going to overrule Ms. Harris is not ready and grant Mrs. Savage is not ready. And we will not proceed as to Mr. Pinner, and we will commence trial and get as far as we can and the time allotted, and then we'll come back and finish up on September the 9th. So with that, do you have any housekeeping issues we need to pick up?
Judge, I did circulate proposed exhibits to the parties last week and received several emails that there weren't any objections to those exhibits. And so if we can just go ahead and bring those up and admit them, that way they're in the record already, and that might help speed things up.
Why don't you go ahead and state what they are by number and name, and then we'll go with the objections.
So as petitioner's exhibit number 1, Judge, we have the temporary order following adversary hearing in this case. Petitioners 2, make these a little smaller. We have Ms. Gomez's family plan of service. Petitioners 3, we have the status hearing order from this case. Petitioners 4, the initial permanency hearing order before final order from this case. Petitioners 5, we have the permanency hearing order before final order from this case. Petitioner 6, we have the order adjudicating non-parentage for the alleged father, Donald Howard Sigler. And then petitioners 7, we have the waiver of interest from Mr. Rodriguez. Those are all the proposed exhibits, at least for 2 days hearing, Judge.
Any objections to petition 1 through 7?
No, Your Honor.
No objection.
1 through 7 are admitted.
Thank you, Judge. Judge, at this point, then I'd like to call Ms. Powell. Thank you, Judge. Ms. Powell, can you please state your name for the record?
Powell.
And are you the permanency specialist that's assigned to this case?
Yes, I am.
Okay, and how long have you been the permanency specialist on this case?
Since the case came in from investigation, so almost a year.
Okay. Are you familiar with the reasons for removal in this case?
Yes, I am.
Okay, and then did you participate in the creation of the family plan of service to address those reasons for removal in this case?
Yes, I did.
Okay. And was that family plan of service created during a family group conference?
Yes, it was.
Okay. Can you tell me what the reasons for removal of the child were back in September of 2023?
Prenatal drug exposure. I knew that was born to Miss Sigler, exposed to methamphetamines.
Okay. And did you discuss Ms. Gomez's drug use with her?
Yes, I have.
Okay. And did Ms. Gomez make any sort of admissions to you regarding her drug use?
Yes, she did, and later tested for me. She admitted to drug use.
Okay. And did she admit to you what specific drugs she used?
Methamphetamine and marijuana.
Okay. Did you discuss Ms. Gomez's drug use while she was pregnant?
She didn't want to talk about that.
Okay. During the course of this case, have you had ongoing conversations with Ms. Gomez regarding her drug use?
I have attempted.
Okay. And what is your understanding of Ms. Gomez's current drug use?
That she's still currently using methamphetamines and marijuana.
Okay. And when's the last time you had contact with Ms. Gomez?
Last month, I believe, the last week of July.
Okay. And why do you believe that Ms. Gomez is still actively using methamphetamine and marijuana?
Just from her appearance and her failure to engage in inpatient rehab.
Okay. I'm going to scroll down to her family plan of service for this matter. Can you tell me what services Ms. Gomez was ordered to complete as part of this case?
She was ordered to complete an OSAR assessment in the event of a positive UA or hair test. She was ordered individual counseling, psychological evaluation, and parenting skills, as well as dealing with her resource management.
Okay. And so you said that there was an OSAR evaluation if she tested positive on a random drug screen. Was Ms. Gomez referred for an OSAR evaluation?
Yes, she was.
Okay. And do you recall when she was referred for that evaluation?
Ooh, that OSAR, she was referred, it was scheduled on the 20th of March. She missed that, so it was rescheduled for April 22nd, and I believe she did submit to that assessment at that time.
Okay. And were there any services that were recommended for Ms. Gomez as part of that OSAR evaluation?
Inpatient rehab.
Okay. And did you attempt to get Ms. Gomez into an inpatient facility?
Yes, up until the end of July, yes.
Okay. And what facilities did you work with in order to get Ms. Gomez admitted?
Journey and Nexus, but mostly we leaned on Journeys and San Angelo. That was her preference.
And did Ms. Gomez have the opportunity to enter inpatient treatment?
She had the opportunity to secure a bed and did not. She didn't keep in touch with the facility.
Okay. And when a parent is referred to inpatient treatment, what is the expectation for securing that bed?
Accountability. They need to reach out to the facility. They're then put on a wait list. In her case, she at one time had insurance. We went through the matter that it didn't cover the rehab, so she was instructed to call them every day until a bed would become available. I reached out to them in July. They did have a bed available, and I tried to get Ms. Gomez to call them because I couldn't do it for her. So it's accountability and her being persistent is what they needed her to do.
Okay.
And keeping in contact with them.
Okay. Were there any other recommendations from that OSAR evaluation other than inpatient treatment?
And to continue within the individual counseling.
Okay. Let's talk about individual counseling then. Was Ms. Gomez referred to individual counseling?
On October 10th, she was referred to Chandra Esparza for individual counseling.
Okay. And did Ms. Gomez engage in counseling with Mrs. Sparzel?
No, she did not.
Whose responsibility is it to set up the sessions of individual counseling?
I set the initial 2054. The counselor then reaches out to Ms. Gomez. Ms. Gomez did not return her phone calls.
Okay. And so during the course of this case, were the 2054s and the authorizations active for individual counseling?
Yes, they were.
So did Ms. Gomez have the opportunity to engage in individual counseling throughout the course of this case?
Yes, she did.
Okay. Did she fail to complete those sessions of individual counseling?
She failed to complete any of them. Yes.
Okay. You said she also was ordered to complete a psychological evaluation. Did Ms. Gomez complete that evaluation?
She did not.
And who was Ms. Gomez referred to in order to complete it?
Stonebridge Behavioral Health.
Okay. And was the 2054 created for Stonebridge?
Yes, that was done on the 12th of October.
Okay. And whose responsibility is it to set up the psychological appointment?
They would have reached out to Ms. Gomez to set the appointment with her. She did not respond. She didn't answer her phone.
Okay. Did Ms. Gomez ever complete that psychological evaluation?
She did not.
Okay. Finally, there's you said that she was referred to a parenting program?
Correct.
Okay. And what parenting program was she referred to?
The Strong Families Padres program.
Okay. And did that require 2054?
Yes. Actually, no. It required me to refer her. I referred her, and she did not enroll in the program.
Okay. Were there any other services on her family plan that we haven't already discussed?
I believe those were the only services.
Okay. At any point in this case, did Ms. Gomez engage in her services outside of completing the OSAR evaluation?
No, sir.
Okay. Did you also make requests for Ms. Gomez to submit to random drug testing throughout the course of this case?
Yes, sir.
And did she comply with those requests for random drug testing?
Only once. Well, she took 2 tests, a hair and a urine, on 2 different days, but those were the only tests she took in March.
Okay. And those were the tests that resulted in the referrals for the OSAR evaluation?
Yes.
Okay. Were there other referrals sent or other requests made for additional drug testing during the course of this case?
Throughout the case, I tried to set up randoms, but no, outside of me setting up random testing, no.
Okay. Did Ms. Gomez have a visitation schedule with the child?
Yes, she did.
Okay. And what was that visitation schedule?
Weekly visits, 2-hour visits at the caregiver's home.
Okay. And did Ms. Gomez participate in those?
She participated up until her last visit was February 15th of this year.
Okay. Since that last visit, has Ms. Gomez asked you to set up any additional visitation?
She has not.
Has Ms. Gomez reached out to you to ask to see how her child is doing?
She has not.
Has Ms. Gomez provided any sort of birthday cards, holiday cards, or anything along those lines during the course of or since February of 2024?
I believe she sent $20 to the caregiver, and that was it.
Okay. Has Ms. Gomez attempted to maintain contact with her child since October of 2024?
Not since February 15th. She has not.
Where's the child currently placed?
She's placed with Jalissa Gomez and Jonathan Estrada, her maternal uncle and aunt.
Okay. And how long has she been in that placement?
Since she was released from the hospital.
And how is she doing there?
She's doing great.
Have you had the opportunity to observe the relationship the child has with their aunt and uncle?
Yes, I have.
And can you describe that relationship for us?
She's very bonded to the whole family. Ms. Gomez, Jalissa Gomez, is an excellent caregiver. And we have no concerns for her physically, her physical safety. There are no concerns at all with this caregiver. She's very bonded to her aunt, especially her aunt.
Okay. What is the current permanency goal for the child?
Relative adoption.
Is it by her aunt and uncle?
Yes, sir.
Okay. Are they currently licensed to adopt?
They are not. They're working through the process.
Okay. And where are they in the process to become licensed?
They were working services through Divinity, the agency Divinity. However, due to a very old domestic violence charge from over a decade ago, they were not selected for licensure. So we're trying to find another agency that will give them a straight license to adopt only, not to foster. So that's where we are in the process.
During the course of this case, Mr. Michael Anthony Rodriguez was identified as an alleged father. Is that correct?
Correct.
And did you have contact with Mr. Rodriguez?
In the beginning, he accepted my phone calls. When I let him know, I advised him that she named him as father, as a potential father. And after that, he discontinued any contact with me.
Okay. And do you know when you had contact with him?
It would have been earlier in the year, perhaps February or March.
Okay. And Mr. Rodriguez has executed a waiver of interest in this case. Is that correct?
Correct.
And at the time that Mr. Rodriguez executed that waiver of interest, was he represented by an attorney?
I believe it was Mr. Saldivar. I believe so.
Okay. And do you believe that Mr. Rodriguez had the ability to review the waiver of interest with his attorney?
Yes.
Okay. And do you think that, or do you believe that Mr. Rodriguez was able to have all of his questions regarding the waiver of interest answered by his attorney?
Yes.
Did the department promise Mr. Rodriguez anything in exchange for the waiver of interest?
No.
Did the department threaten Mr. Rodriguez in any way for the waiver of interest?
No.
Is it your understanding that Ms. Rodriguez signed the waiver of interest freely and voluntarily?
Yes.
And that he did so believing that waiving his interest as a potential father for the child was in the child's best interest?
Yes.
Okay. And did Mr. Rodriguez sign the waiver of interest in front of a notary and 2 witnesses?
Yes.
Okay. And the court's already entered this into evidence as petitioner's exhibit number 7, correct? Did you hear my last question, Ms. Powell?
I'm sorry, can you repeat that?
Sure. And this document's already been entered as petitioner's exhibit number 7, correct?
Correct.
And you signed the document consenting to the department being designated as the managing conservator as the representative for the department in this case.
Correct.
Okay. With regard to Ms. Gomez and Mr. Rodriguez, Judge, I pass the witness.
Ms. Harris?
Ma'am, did Ms. Sigler ever?
Just, I'm sorry. We have about 5 minutes before we need to start the next hearing. You can get some stuff in, or should we just recess now?
I'll be really quick, Judge.
Okay, go ahead.
Did Ms. Sigler ever express to you any kind of a desire to get treatment in inpatient?
Mr. Sigler?
I'm sorry, Ms. Gomez.
Yes, ma'am, she did.
And was it your requirement that she show some accountability to get into those rehabs, or was it their requirement?
It was their requirement.
So do you think that you did all that you're able to do in order to be able to help her?
I did.
And did she express her desire for rehab more than once?
More than once, but not the last time I spoke with her.
And each time she expressed that desire, you tried to help her make connection with an inpatient facility?
Yes, ma'am.
Since the child is with family, is the hope that she can have a relationship someday with her child and its adoptive parents after she's received treatment?
Yes, ma'am, that is the hope.
No further questions, Judge.
Ms. Savage? Actually, I'm sorry, Mr. Saldivar.
Yes, Mr. Rodriguez wanted the waiver of interest filed with the court. Is that correct?
Correct.
And he was offered the opportunity to do DNA testing, and he did not want to do that. Is that correct?
Correct.
And he did not want to have any relationship with his child. Is that correct?
Correct.
Is the department accepting the waiver of interest for Mr. Rodriguez?
Yes.
Pass the witness, Judge.
Nicole, say anything?
Yes, Judge, just briefly. Ms. Powell, the current placement is incredibly protective, correct?
Correct.
And if Ms. Gomez comes around, you have no concerns with them being able to keep Ari safe, correct?
Correct.
Okay. And will you be assisting the placement with finding a new agency moving forward?
Yes, ma'am. We're trying to assist her.
Okay. Are you aware of any times Ms. Gomez has gone to try to see Ari?
I'm aware that she's visited on the family property. However, Miss Jalissa Gomez will not let her approach the home or be around Ari.
So you're satisfied that even if Ms. Gomez is coming around, if she's not appropriate, Ms. Julissa Gomez is going to make sure that Ari isn't affected by that, correct?
Correct.
I'll pass the witness, Judge.
Out of time. I don't know, Ms. Savage, do you have anything we'll get on the record today?
No, Your Honor.
And with that, the court's going to recess this trial. And we're going to recommence on September the 10th, actually, not 14th, it's September 10th, 2024 at 2:30. And at that time, Mr. Penner's answer period shall pass, and matter will be right to continue the trial at that time. Anything further we need to take up?
No, Judge.
Okay, thank you all for your service. I'll see you on September 10th at 2:30. All parties are excused.
Thank you, Judge.
District Court of Medina County, Texas. Court is streaming outside of Medina County via YouTube and Zoom. Are there any objections?
No objections.
No objection.
No objection.
With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge. Drake McKeska, attorney for the department.
Christy Knott, permanency supervisor with Belong.
Ontropolis, permanency specialist with Belong.
Richard Soller, attorney for the mother, Ms. Ramirez. Ms. Ramirez, can you unmute and announce, please?
Connie Ramirez.
There you go.
Jennifer Harris, attorney for respondent father, Mr. Velasquez. He's not present, but I'm ready.
Your Honor, are we missing Ms. Acevedo?
We are.
Sandy Hudson, Tri-County CASA.
Irene Acosta for the child. I'm ready.
Jill Roden, Tri-County CASA.
Anybody here from Ms. Acevedo?
I'm going to reach out to her right now, Judge.
Anyone else that has not made their announcement yet? All right. We're just waiting on Ms. Acevedo. As a recap, we had our permanency review before final order back on May the 14th. At that point in time, kiddos were in monitored return with Ms. Ramirez, and everything was going well there. Everything was up to date. And my understanding at that point in time was that we were on a track to reunification. Mr. Ramirez and Mr. Ramirez were both in compliance. Mr. Velasquez at that time was not, but I heard you on mediation. Where do we stand today, Mr. McKeska?
So, Judge, we did attend mediation. However, Mr. Velasquez did not appear for mediation, so we were not able to reach an agreement. As far as today is concerned, the department is asking to dismiss the petition with regard to the oldest child. So Ms. Ramirez and Ms. Ramirez be dismissed out with regard to that child. With regard to the youngest child, with Ms. Ramirez and Mr. Velasquez, there's a prior order that was transferred and consolidated into this case that addresses conservatorship and it addresses possession and access. However, it did not address child support. And so what we're asking today is that the court defer back to that order on the conservatorship and possession and access provisions, but modify that order with regard to child support.
Okay. Are there any responses or objections?
No objection, Your Honor.
No objection, Your Honor.
No objection.
Well, as long as Ms. Acevedo does not object, which I don't see why she would, we can move forward with that. So anything that we need to take up prior to, you're asking for a dismissal as to Ramsey. So you're wanting severance?
Judge, I don't know if we necessarily need to sever out, since there wouldn't be an order with regard to Ramsey.
You're right.
And I mean, it would just be clear in the final order that the claims in the petition to that child were dismissed, and that there's no final order entered with regard to that child, and then the other provisions of the final order just address the youngest.
I agree. Just we need a finding in there that there's no relief granted on that petition, and it's dismissed as to Ramsey. So if there's no objection, when Ms. Acevedo gets in, I'll go ahead and take care of that. What evidence do you need to put on as far as your substantial material change, or do you want to put on regarding the modification?
Judge, I would I'd call Ms. Powell in that regard. And then also I believe we would need to call Ms. Ramirez with regard to Mr. Velasquez's income and those sorts of things. Okay, and do all parties, I don't know what sort of notice they might have had, but does everybody waive citation and notice of a hearing on a motion to modify?
Yes, sir.
Yes, Your Honor.
Ms. Acevedo, could you please announce for me?
Yes, Judge. Rochelle Savella for Mr. Ramirez. We're ready on.
Okay, just to get you up to speed, the department has announced an intention to dismiss S.T. Ramsey and then revert back to a prior court order regarding Creed that we have already consolidated into this case, but the department would like to have the court hear a motion to modify as to the child support in that case. And all parties had, just before you got on, agreed to waive citation and notice as to the motion to modify on the record. Are you in agreement with that?
Yes, Judge.
Okay, you proceed, Mr. McKinsey.
Thank you, Judge. Judge, I would like to call Ms. Powell.
All right, she's been sworn.
Thank you, Judge. Ms. Powell, can you please state your name for the record?
Ona Powell,
And how are you currently employed?
as a permanency specialist with Belong.
Okay, and are you the permanency specialist that's assigned to this case?
Yes, I am.
Okay, and how long have you been the permanency specialist for this case?
Since the beginning of the legal case.
Okay.
Yeah, for the parade. That's
Where-
real good. Like, I'd eat that by it.
Go ahead.
Thank you, Judge. And Ms. Powell, are you familiar with the reasons for removal in this case?
Yes, I am.
Okay, and were those reasons for removal addressed in the creation of the family plan of service?
Yes, they were.
Okay. So with regard to the children, what was the basis for the removal in this case?
The basis for the removal was domestic violence, and with the children allegedly present during the domestic violence.
Okay. And were family plans of service created for the 3 individual parents in this case?
Yes, they were.
Okay. And with regard to Mr. and Mrs. Ramirez, did they successfully complete those family plans?
Yes, they did.
Okay. And the children have been in a monitored return with the Mr. and Mrs. Ramirez, is that correct?
With Ms. Ramirez since March, yes.
Okay. And how has the monitored return gone?
It's going well.
Do you have any concerns for the care of the children in Ms. Ramirez's home?
No, I do not.
Okay. With regard to Ramsey, do you believe it's in Ramsey's best interest for the court to dismiss the petition today?
Yes, I do.
Okay. And you believe that both parents have successfully addressed the reasons for removal?
Yes, they have.
Okay. With regard to Mr. Velasquez, was he ordered to complete services for this case?
Yes, he was.
Okay. And what services was he ordered to complete?
I believe a psychological evaluation, random drug testing, and parenting classes.
Okay. And has Mr. Velasquez been compliant in those services?
He's completed his psychological evaluation. He has not been compliant with drug testing, and he has not exercised his right for visitation. And he was taking parenting classes, but he was dismissed from the program due to absences.
Okay. And do you believe that Mr. Velasquez has successfully addressed the reasons for removal in this case?
I do not.
Okay. Do you believe that it'd be in Creed's best interest for the court to revert back to the prior order that Ms. Ramirez and Mr. Velasquez had for Creed?
Yes, I do.
Okay. So do you believe that it's in Creed's best interest for Ms. Ramirez to be named as sole managing conservator of Creed?
Yes.
Or to continue as the sole managing conservator?
Yes.
And it would be in Creed's best interest for Mr. Velasquez to continue as that possessor conservator?
Yes.
Okay. Do you also believe it would be increased best interest for Mr. Velasquez to pay child support?
Yes, I do.
Okay. I pass the witness, Judge.
Mr. Tovar?
Yes, to your knowledge, was Mr. Velasquez working?
Yes, he was.
And where was he working?
I believe he works in the oil field, but the name of the company escapes me.
Okay, and to your knowledge, has he been employed throughout this entire case?
Yes.
Okay, and did you ever ask him during the course of this case for any financial information?
No, I did not.
Okay. To your knowledge, has he been paying anything in child support or in-kind support to the child?
No, he has not.
Pass the witness, Judge.
Ms. Acevedo?
No questions, Judge.
Ms. Harris? Your client is logging in now.
Did you ever see any of Mr. Velasquez's pay stubs?
No, ma'am.
Do you know what he makes then?
No, ma'am.
No further questions, Judge.
Ms. Acosta?
Thank you. Ms. Powell, with regard to the prior order regarding Creed, what does the visitation in that order look like?
It's handled by Ms. Ramirez, and it's deemed as she deems fit for Creed to visit with Dad.
And throughout this case, Ms. Ramirez complied with all of her services learning and has demonstrated that she can be protective of her children, correct?
Yes, she has.
And so do you have any concerns that this order doesn't provide enough supervision for the children?
I do not have any concerns with this order.
Okay, and moving forward, you feel confident that Mrs. Ramirez has learned tools through her or gained tools through her services that and that allow her to continue to keep the children safe, correct?
Correct.
Okay. And in this case, she has demonstrated that what steps she will take to keep the children safe if someone is threatening her or the children, correct?
Correct. Correct.
And with regard to Mr. Ramirez, he has completed all of the services and you have no concerns with him with regard to Ramsey, correct?
Correct.
Would you have concerns with Mr. Velasquez considering that he hasn't completed any of his services?
Yes, I would.
Okay. And when was the last time you had contact with him?
The last time I had contact with him, physical, and spoke with him, I'm going to be honest with you, it had to be maybe January, the end of last year, but I do reach out via text. He just doesn't respond.
And he's been aware of this case, correct?
Yes, he is.
I'll pass the witness, Judge.
Any redirect?
No, Your Honor.
Anybody else have any other questions for Ms. Powell?
No, Your Honor.
Any other witnesses?
Judge, I would like to call Mr. Velasquez.
All right, Mr. Velasquez, could you unmute and state your name, please? Please.
Anthony Velasquez.
Thank you. Go ahead, Mr. McKesson.
Thank you, Judge. Mr. Velasquez, are you currently employed?
Yes.
Okay, and where are you currently employed?
Mesa Well Service.
Okay, and what do you do for Mesa Well Service?
I'm an operator.
Okay, and are you paid by the hour or are you salary?
I'm paid by the hour.
Okay, and how much do you make per hour?
$26.50 an hour.
Okay, and how many hours a week do you work?
About I'm doing state work right now, so we're federal funded. I'm doing about anywhere from 40 to about 50 hours at times.
Okay, when you work over 40 hours a week, does that count as time and a half?
Yes, sir.
Do you get paid weekly, bi-weekly, monthly?
Every 2 weeks.
On average, how much do you get paid every 2 weeks?
I'm not too sure. I did get direct deposit. We are state work, so anytime the state is off, we are off. So sometimes it's not even 40 hours. Or every holiday a state worker has, we have the same holiday. So I'm not too sure. I haven't checked my exact.
Okay. And how long have you been employed with Mesa?
I started with them February 2nd. So this is a different company. I have not received. I know what I looked at, I'm probably 40,000 less a year than what I was at my last company, my last W-2s.
Okay. And do you receive a W-2 or you're a contractor?
I receive a W-2.
Okay. So they
Yeah,
they deduct taxes and Social Security and Medicare and all that sort of stuff.
Yes, sir.
Do you pay any sort of private health insurance through your employer?
I pay health insurance and dental.
Okay. And do you have Creed on your insurance?
No, sir. I believe he's on Ramsey's and Miss Ramirez's.
Okay. Do you have any other children that you're responsible for providing support to?
Yes, I'm not child support, but I do have custody of both my daughters.
And so they live with you?
One lives with me and one's on temporary order with mom in North Dakota. So I have a 16-year-old daughter with me.
Okay. And your daughter that resides in South Dakota, do you pay any support for her?
No. That's North Dakota, Williston, North Dakota.
North Dakota, I apologize.
Yes.
Pass it, Mr. Judge.
Mr. Salazar.
Yes, what was your yearly income for 2023?
2023, I believe, it was like, I want to say 80,000, 70,000. I had two separate companies, I had sister companies. So one was like 30,000 and the other one was like 40, I believe. So
Okay.
my W-2s were with Miss Ramirez, so she would have the exact numbers.
So in 2022, did you make $97,287 for the year?
Can you repeat that?
So you more money.
I'm sorry, Judge, I can't hear what he said.
What was that?
Mr. Velasquez, you're breaking up. Can you turn off your video so that you have more bandwidth for your voice, please?
Oh, yes.
Okay. Now,
Okay, can you hear me?
yes, sir. Mr. Saldivar, ask your question about
Yes.
97,000, please.
Yes, in 2022, did you make a gross pay of $97,287.83?
Both with a company that I was established for 8 years, over 8 years.
So is that a yes, sir, for the 2022?
We just lost him.
Just for the record, he did indicate that Miss Ramirez does have his W-2 information.
I heard that.
Okay. I think he's back, Judge.
Hello?
All right, Mr. Velasquez, can you hear me?
Can you hear me?
Yes, can you hear me? Mr. Velasquez, can you hear me? I think we're going to continue to have this problem. I don't think it's going to get any better. Does anybody else have any other questions for Mr. Velasquez?
No, Your Honor.
I
Can you hear me?
did, Your Honor, but I don't know if it's going to do any good.
Mr. Velasquez, can you hear me? All right, we're gonna move on because we're not getting anywhere. Okay. Maybe if he logs back in, it'll be more clear. But at this point in time, I think I've heard what I need to hear from everyone on the child support issue. Any other evidence anyone wants to present?
Judge, I can present that we do have his W-2. Ms. Ramirez has his W-2 from 2022, showing his gross pay of $97,287. I mean, if you need that admitted into evidence, Judge, I could do that.
I think that would be appropriate. Do you screen shares on if you have it?
Yes, Judge. Let me see your share.
And Your Honor, I just have arguments.
Okay.
Okay, Judge, I'm trying to see if I can make this bigger.
If we're on YouTube, are we on YouTube, Your Honor?
I can stop sharing.
I don't mind it being emailed to you to take a look at so that it won't be on YouTube.
Judge, I can email you. I can email you documents, Judge. I do have some of 2023, Judge, that he had testified to, so I'm gonna include that, and I'll include all the parties in the email.
That's fine. Okay. Any other evidence we need to take up before I hear argument?
No, Judge.
All right, then let me go ahead and we'll start with the department.
Yes, Judge. So just to reiterate the department's request for today, it would be to dismiss the suit with regard to Ramsey, the oldest child, and not enter any sort of final order with regard to him or the parents with regard to that child. With regard to Creed, we are asking the court to just re-implement the conservatorship provisions naming
for that child as well. We would ask that child support be based upon what he testified to, the $26.50 an hour for 50 hours a week, or based upon a recent pay stub that he can provide.
Ms. Acosta.
Your Honor, with regard to Ramsey, Ramirez and Mrs. Ramirez, I believe that should be non-suited. I'm in agreement with the department. I also believe that child support should be ordered for Creed. I think that the modification is in the best interest of him. Mrs. Ramirez has him 100% of the time. And I mean, by statute, she's entitled to child support. So it should be ordered. Whatever evidence you have with regard to the numbers, I'll defer to the court. But I mean, she has Creed 100% of the time. So I think that should be taken into consideration.
Thank you. Ms. Hudson, does CASA have any views or opinions on this?
Yes, sir. I'm in agreement. CASA's in agreement with the non-suit and do think it's in Creed's best interest for child support to be ordered by the court based on the amount.
Okay, thank you.
Thank you.
For the purposes of the final trial, court finds that it has jurisdiction over the subject matter of the parties of the suit. Court finds that all parties entitled citation and notice are duly cited and served. That being said, the court will grant the department's request to non-suit and dismiss the portion of the case related to Ramsey and grant no relief in that particular part of the suit to the department. And court finds the child is placed in a monitored return with Mr. and Mrs. Ramirez and placement is safe and appropriate, meeting his needs, and there's no safety concerns at this time. Court finds that requested dismissal is in the best interest of the child. The court will continue the case as to Creed pursuant to the order that existed prior to this case and was consolidated into this case. The court will grant the request, hearing no objection, to modify the child support portion of the order only. The court will continue to name the mother as the sole managing conservator to Creed and Mr. Velasquez as the possessory conservator. And the possession and access stated in that order will remain the same. Court finds that there is material and substantial change in the circumstances of one or more parties, and that it's in the best interest of the child, Creed, to modify the child support version or child support portion of the order. I don't think it would be fair to Mr. Velasquez for me to make a ruling on the exact amount of the child support right now. I'm going to give the parties until 5 p.m. today to submit any supplemental information you have on behalf of your client as to the child support amount. The court heard evidence as to what he's making right now per hour and how much he's working per hour, and that he gets time and a half, and that he gets paid every 2 weeks, and he pays dental and health insurance. And didn't hear any evidence of any other orders to support another child not before this court. I did hear evidence that he has daughters and has possession of them at times. I'm not sure if it's 100% of the time. I know one of them is in North Dakota or South Dakota right now. So I want to give everybody the opportunity, since the child support modification is before the court today, and it sounds like Mr. Velasquez was having some hard time communicating with us. So I think it would be appropriate just to allow the parties until 5 o'clock today to present any other evidence that you have. Mr. Saldivar sent some stuff, and so it's only fair that everybody else has the opportunity to send in whatever they want to send in too. Make sure everybody gets a copy of it. I'm not going to look at anything until I know that everybody is aware of what everybody else has sent. If you didn't send it to everybody else, I'm not even going to look at it. Then that will be the order as to the modification. We just don't have a specific amount yet. But I am ordering that he will pay the amount that is determined by the court after seeing all the evidence, beginning October 1st, 2024. Whatever that modified amount is, that will begin October 1st, 2024, and be payable thereafter on the 1st of each month. And based on what I see, I'm also going to make an order as to the insurance. I mean, if he's paying insurance, then he has a right to have a percentage of that included in the determination of what his child support is. So I want to put it on the record too that I'm also going to examine that. Mr. McKesky, is there anything I failed to address? What I'm concerned about is I'm not putting a number on the record here right now, but in order for it to be enforceable, it has to be a specific number. So I want to make sure it's on the record that I'm giving the parties the opportunity to present a little more evidence by email before I rule on it. And then what I'll also do is include that order, that number in my order, and then give you all an opportunity to review it and check it before the court signs off on the order. Anything else, Mr. McKesky?
No, Judge.
Okay. Does anybody have any issue with my plan?
No, Your Honor.
I want to say that this case started out pretty contentious. We had some long in-person hearings on this case, and there was a lot of evidence presented. But what I want to say is, Ms. Ramirez and Mr. Ramirez, I'm really impressed with both of you and how you got into this case. You didn't want to be in it, and I understand that, but you did what it took to get out of it and to get out of it successfully. And I hope that, from what I'm hearing, you made some improvements and you learned some things, and that's only going to serve you and your children better. And so my hat's off to you, and I want to give you a round of applause for doing a great job, because we don't see that in every case, but when we see it, it makes me really happy. So thank you for doing the hard work. Anything further?
No, Your Honor.
Okay. All parties are excused. Have a good afternoon.
Thank you.
Thank you, Judge.
Thank you, Judge.
In the 454th Judicial District Court of Medina County, Texas. Court is broadcasting by Zoom and YouTube outside of Medina County. Are there any objections?
No, Your Honor.
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right. With that, Mr. McKesky, would you please begin the announcements?
Yes, Judge. Drake McKesky, attorney for the department.
Christy Knott, permanency supervisor with Belong.
Catherine Shove, permanency supervisor with Belong.
Kimberly Hernandez, permanency caseworker with Belong.
Richard Solivar, attorney for Mr. Roscoe. We're ready, Judge.
Brandon Wong.
Go ahead.
Sorry, go ahead, Deborah.
Deborah Fuller, attorney and guardian ad litem for the children. Ready, Your Honor.
Brandon Wong, attorney for Grace Spence. Not ready, Your Honor.
Lana Pearsall, attorney for Miles Benz, who's present and we're ready. Mr. Benz, can you unmute and introduce yourself?
Miles Benz, Paisley's father.
And we're ready.
Joel Roden, Tri-County CASA.
Anyone who's not an attorney or will be giving testimony, please raise your right hand. Thank you. We're here for a final trial. Mr. Wong has announced not ready. I'm aware that there was a motion filed Friday. Is that correct?
That is correct, Your Honor.
All right. Are there any other motions that we need to take up this morning before the final trial?
Not that I'm aware of, Judge.
Okay. Let me go ahead and hear from you, Mr. Wong, on your motion and what you're seeking today.
Yes, Judge. We're seeking a continuance and extension of the trial setting for an extra 6 months or 180 days. There have been a significant change of events and circumstances for how this case was pending for the entire duration. My client has been always under the impression and been told, especially in my office from the CPS caseworkers, that this case was always on a reunification path, which included herself. At the time of mediation, it was stated that that is not the case, and it was explained that her rights were going to be terminated, and that is highly contradictory to what we have been preparing for the duration, Your Honor. The most recent orders in place all state reunification with the family, and now that they're alleging that it should be termination. Additionally, Your Honor, my office has requested the file from CPS since I got in the case back in May of this year, and we were finally able to get approximately 3,500 pages of documents from CPS approximately a week and a half ago. And so, of course, we need additional time to prepare and go through all of the CPS file for my client. Considering this is a now termination case, we'd also ask, Your Honor, that we have always been under the impression that the cases were going to be split up with Paisley and Scarlett, because there's additional things that need to be done with Paisley as far as my client was supposed to get reunification, have unsupervised visits, move into visits, et cetera. That has not occurred. And then more recently with Scarlett, there has been communication from Scarlett to my client through various social media accounts saying that she wants access, wants to
Your Honor,
talk.
I'm no object to hearsay.
Well, I just want to hear what the argument is, what you would propose to present. So
Right.
Don't get into the specifics of what she said. Just tell me what you would show.
Of course, Your Honor. We would show that there is no outstanding harm for the case being continued, for both cases being continued for another 6 months. So Ms. Benz can further go through the therapeutic process, finish all the CPS classes, for the kids to go through the therapeutic process, because termination should be the last thing on the list. And, you know, it's kind of the last resort decision that should occur. And so again, Your Honor, my client has been completing and has been attending all of the classes. She has a handful of classes left for the BIP program. It has also, the evidence will show that the child, through her current counselor, Dr. Yates, has made has expressed an interest to speak with her mother, because at the prior hearing, you know, it was told that she did not want to have any contact. And
Objection, hearsay, Judge.
All right,
I'm just going with what the facts
Your Honor, I think
show.
I think Mr. Wong is providing testimony, I mean, and evidence that needs to be done by witnesses and not by his own testimony, and his testimony is not accurate either.
Again, Your Honor,
hang on. I think I get the gist of what you're wanting in your motion, and that's really what I was looking for. It sounds like your client is requesting the court to extend the case basically due to big ticket issues were being your client arguing that she's unaware that she was on a termination track. You just got a 3,000-page file that you've been requesting, and you're asking time to review that. And you believe that the track of these cases is it's incongruent with termination at this time, and you're asking for more time to delve more into some of the things that we've been talking about, including at the last hearing. So that's my understanding of the motion for extensions, and that's essentially what you're arguing, is it not?
That is correct, Judge.
Okay. I'm going to give everybody a chance to respond. We'll start with the department. Mr. McKeska.
Judge, this is probably one of the toughest cases that I've come across regarding the issues at hand and the two separate children and the fathers in the case. It is the department's request today that we move forward with trial with regard to Scarlett. She is in her placement with her father. She's been there for a while. And we believe it's in her best interest to move forward with the final hearing. We would be prepared to move forward with regard to Paisley as well. The child is on track to enter into a monitored return with her father. And so we would ask that, we'd be able to do that. But also believing that maybe dealing with the mother's conservatorship of both children, her rights to both children, for sake of judicial economy, be handled together.
Is the department seeking termination of the mother's rights, considering there's a term or proposed monetary return with Mr. Benz?
That has been one of the things that have been discussed, yes, Judge.
So you are seeking it?
If we were to move forward with trial, that would be our position today, yes.
Mr. Salawar?
Judge, we'd object. We want to move forward on trial. I believe the motions were not timely filed. I don't believe the petition was also timely filed, Judge. So we'd object to notice on that. And we want to move forward, Judge. She's had enough time to work her services. We need permanency for the children at this point, especially my client who's had the child in his home, Judge. So we'd want to request trial to proceed today.
Pearsall?
Judge, I agree with honestly what, well, not Mr. Wong, but with what everybody else said. We absolutely need to move forward to trial. I agree with Mr. McKeska. He said, I wrote it down, that this is the toughest case. We do CPS cases, and they are unique. and they work with really traumatic, unusual issues. And the fact that I think all of us think this is one of the most difficult and extreme cases we've ever worked says a lot. There is absolute harm in doing anything but moving forward with this trial today. One, this motion for continuance and extension was not timely filed or served on any of the attorneys or parties. Two, it requires a showing of extraordinary circumstances, and there are just none. What makes this case tough and isn't the cause for extraordinary circumstances is mother's continued behavior throughout this case. This court has heard through many, many hearings how she has scared the kids, how kids in a very unusual way don't even want to communicate with her, how she has broken and trashed my client's house, how she has filed false charges against him, by the way, she still continues to do. She has falsely involved the police and the fire department where he works. Her level of constant, illegal, dishonest harassment is something I've never seen in 25 years of practice. So there is absolute harm. And honestly, Judge, if we do anything but move forward with this case, I'm afraid I'll see my client on the news as the next dead victim. So I'm asking that we go forward today for these children's safety and for all of the fathers' safety.
Thank you, Ms. Fuller.
Your Honor, I'll start with the surprise of termination. I don't know how that could be a surprise. Her child was sent, Scarlett was sent to live with Mr. Roscoe months ago in March. Then all communication was cut off as well. The concurrent plan has always been adoption, and Mr. Roscoe was able to meet all of her needs. And so she should have been fully aware with Scarlett that the plan was termination. So to come in today and say that she just was made aware of that, if you see the court reports, they all say reunification, then concurrent plan adoption. And my client, Miss Scarlett, the oldest child, didn't want any contact with her mother. She did reach out, and Miss Bentz didn't even tell anybody that she talked to her. You know, it came from somebody else. So even though you ordered her not to have any contact with Scarlett, there was contact, and she didn't tell anybody. We found out through a third party that she had contact. So that's really concerning to me. And as Ms. Pearsall said, you've heard so much evidence of Ms. Bentz's continued behavior that is so alarming in a case. And again, I've been doing these cases for 30 years, and to see the type of activity that Ms. Bentz will engage in with the children, threaten their lives, threaten these fathers. I mean, I don't know how she wouldn't understand that termination was on the table. Mr. Wong filed pleadings late. They're not, so he has no pleadings on file. He had to file them 10 days before the hearing. He filed the motion for continuance late. This case needs to go forward because these children need permanency, and they need to be able to move forward from what they've endured. Scarlett especially has endured horrific abuse, emotional, physical, at the hands of Miss Bentz. I mean, it's the worst type of emotional abuse I've seen in the years that I've been doing these cases. And we need to move forward with that. And with Paisley, the harm that Miss Bentz has committed on all these children, especially young children, you know, the worry is that Paisley wouldn't survive. She's a baby. She's barely a year old. And Miss Bentz is a very unstable, unpredictable individual. She has not been able to overcome any of the issues that brought us into care. And I'm really worried for the lives of these children and for the fathers, because she has gone so far as to threaten and to file charges and to do all these things to try to make them change their mind or make something happen in her favor. And it's just, it's sickening. And we need to go forward, and her rights need to be terminated. And I think she should have known that was the case. I don't know how it's a surprise.
Thank you. Before I hear from CASA and then give Mr. Wong a rebuttal, Mr. McKeska, one of the arguments that Mr. Wong made was the file. I think I heard him say that he had been requesting it since May and had just received it last week. And it's over 3,000 pages. What's your response to that?
So, Judge, I don't know when the file was requested. I'm picking this case up at the 11th hour. Whenever I was looking through the file during and after mediation, I saw the redacted case file had been prepared, which tells me that someone requested it at some point in time. And so I asked Ms. Ortiz to send it to Mr. Wong's office upon seeing it in the file, and that's what we did. If it was requested by a party earlier in the case, then I mean, I defer to the other parties who have the historical knowledge of this. Then it would have been provided originally. I know that Mr. Wong came onto this case kind of late in the game. And so the file may have been provided to Ms. Spence prior to that, to her prior attorney. I don't know. All I can say is that I saw it in the file and that we submitted it to him upon discovering it.
Okay.
Your Honor, if I can add to that, the CPS redacted file was provided to all attorneys of record on May 23rd of 2024. So all attorneys had it for all parties.
Okay. Who was Miss Spence's attorney at that time?
I'm not really sure, Your Honor. This is her fourth attorney. Irene Acosta was the attorney prior to Mr. Wong.
And Your Honor, I can tell you we did not have the file back in May. And I have reached out to my office, I will say, has reached out to prior attorneys, and we have not received any documents from them.
Well, our records show an initial appearance, or substitution, I guess, by your office, Mr. Wong, on May 14th. Does anybody else have any information? Ms. Pearsall stated that the identified file was provided May 23. Does anybody else have any other information on that?
Judge, I can tell you I was not provided with that file. And if I'm searching my emails right now for everything from CPS related to this Spence matter. And this is the first time that we got the file was approximately a week and a half ago.
Okay.
And I doubt if it would have been sent through email, Your Honor, not 3,500 pages. They usually send the flash drive.
Right. And we definitely didn't get a flash drive. And we did get this file through email because they made a link that we were able to download.
Yeah, it's a link that comes through. It's not an email. It's like a link that we get.
Right, but if we got it through email, through a link.
What is controlling here is mitigation. So when did you request the file again, Mr. Wong?
We've been requesting the file essentially continuously when we've been meeting with the CPS workers. And so again, we did request it the last time at mediation, where they even had said that we will agree to give it to you, but we're not going to put it in the mediation report that we agree to give you the redacted file.
Your Honor, I'm sorry, mediation is confidential, and providing that information to the court is against the rules.
Well, hang on. Did you submit any formal requests to the department, Mr. Wong, since May 14th?
So I can look through my file, Judge, but it is our fairly standard procedure. When we get involved in a case, we send a standard form letter requesting all the file for the entire case.
What I want you to do, it's 11:06. I want you to take 10 minutes and look for your requests, because in my opinion, there's a very compulsory feeling that I have right now that we need to move forward. But if you can show that your attempts to procure a 3,000-page file have been ignored for 4 months, then I'll consider that. But I need to see some evidence of that. So I'm going to give you 10 minutes to look for it. We'll be back at 11:17. Go ahead.
Judge, I show in my file notes that we reached out back on May 10th, on July 16th, regarding the file. I do show we did receive partial file, but it only included 85 documents. I did not, I can tell the court that it is not, those 85 documents are definitely not the 3,500 pages of reports that we received a week and a half ago. So again, Your Honor, we did not receive the complete file as requested, and we have made numerous requests. There have been a number of different caseworkers, which I understand occurs, and that could be part of the issue of getting the file. And just, again, Your Honor, where we'd ask that we'd have time to actually review the entire case file.
Do you have any copies of formal requests made to
I have some emails, Your Honor, and I do have emails from CPS responding back with the files. And so, yes, I do have the emails, but of course that is for the earlier request. But the continuing request, those have been made, and I do have notes in our files, and I do have emails, of course, saying that they'll call us back and give us information.
And Judge, while we were in recess, I was also doing some digging. Ms. Ortiz was able to locate an email from the software program that we use. It's the best way to describe it is a secure Dropbox program. Whenever we create the package that gets sent out to the parties, it creates a link that's active for 7 days. If a party doesn't access the information within that 7 days, then the package is deleted and that link is deactivated. So we do have an email from May 31st of 2024 that shows the deactivated link. In that email, it also shows all of the email addresses that did not open the file. The only attorney or the only parties that were included on the email that opened it were Ms. Schoaf and Ms. Savage at the time. But everybody else's emails, including Mr. Wong's, is included on that email showing that it wasn't opened whenever it was sent back in May.
Was that email to a link that would have included the information that was provided last week?
Yes, Judge. That it would have been that was the redacted file that was sent back in mid-May, like I say, or towards the end of May. Probably May 24th is when the email would have been sent, since it had a deactivation date of the 31st, which would have been 7 days later.
Can I get the email address that was sent from so I can search that in my inboxes? Because it could have gone to my junk or spam. That's the issue.
Sure.
Well,
so
and Judge, if I can add,
let him give the email address so that we can.
Yeah, it's
Mr.
Brandon.
Wong, are you okay with him stating the email address in open
I'm not my email address, but the sender. If I could get the sender, then I can search that to see if that actually came to my inbox or if it came to my spam.
The sender is probably going to be the Texas Department of Family and Protective Services notification service.
While he's looking for that, Ms. Pearsall, what were you going to say?
Yeah, I found that email specifically while we were talking. It was generated on behalf of that mailbox by Ms. Ortiz, Lorraine Ortiz, who works for Mr. McKeska's office. I confirmed with her during the break that it was set on myself and specifically to Mr. Wong and the same link. And what Mr. Wong is saying, what he did get at some point was, some sort of partial documents, but I can tell you it's 3,593 pages, which is exactly what he's complaining he received again. But that was sent out to all attorneys on May 23rd. And Judge, if we don't open the email, I don't know how we can blame anybody else for that.
No,
and Your Honor, I did want to add something, Your Honor. When Mr. Wong said that we had mediation recently, and so it was a surprise, it was termination. We actually had a mediation scheduled and everybody attended except Ms. Spence on July 30th. And it was made very clear at that time that termination was the plan. We had to reset it because Ms. Spence was not able to attend. And so then we had it on the 15th of August. So he was fully aware on July 30th because we did attend that mediation for at least an hour discussing what the plan was. So to say that he was only made aware last week is not true.
Judge, and again, the reason that Ms. Spence wasn't, to add context, there's a medical emergency. And again, there was nothing discussed with my client about termination because we didn't actually discuss anything about the case other than a reset date. And I can see in my inbox, Your Honor, I did get 2 emails from Lorraine. When she sent it from Lorraine, I got that one, Your Honor, on 8/19. The other did go to my spam box from May. I do see the one from May, but again, it's in my spam. But I got the one because for some whatever reason, one of them popped up as lorraine.ortiz@dfps.gov via tel something. The other popped up as Texas Department of Family and Protective Services, and that went to the spam. I don't know why the inbox named them differently, but for whatever reason, one did go to spam, the other went to my inbox.
All right.
Fortunately, that's not a reason for a continuance.
Well, I don't want to put any more time into this. I wanted to give all the parties an adequate opportunity to state their position on this motion. because one of the things I heard, and I quoted it, was this is one of the most significant extreme cases we've ever worked. And I am aware of what's going on. And so the thought in my mind was, well, if it's the most significant extreme case we've ever worked, then I need to really think about whether or not we have extraordinary circumstances and whether or not we have best interests for a 263-401 motion. And based on what I've heard this morning and what I know about this case, and that's why I gave you the opportunity, Mr. Wong, I believe that the file was provided, and you have a duty to mitigate whatever issues might exist when it comes to discovery. I almost feel as if we're in a situation right now where we're waiting a long time to say I never got it. I understand that you followed up and you requested some things and you got answers, but I don't have any reason to question that the email was sent out back in May. There's no evidence that disputes. There's no contravening evidence that email was sent out. And, you know, we're all custodians of our own email accounts, whether something's going to our inbox or our spam or our junk mail. I mean, that's on us. And so I don't believe that what I've heard this morning argued is going to rise to the level, even if I were to hear evidence about it, it's going to rise to the level of extraordinary circumstances. And from what other arguments I've heard from the people involved in this case, it doesn't sound like it's in the best interest for us to put this off. So motion's denied. I'm also going to find that the motion was not filed timely. It's supposed to be 3 days, and you can't include the day of the hearing. So if it was filed on Friday, you know, or I don't know that everybody had sufficient notice to prepare for an extension hearing this morning, is what I'm trying to say. I'm going to find there's no extraordinary circumstances and it's not in the best interest to extend, and we're going to move forward with the trial this morning. What housekeeping issues do we need to take up before we begin?
Judge, I did send out copies of proposed exhibits last week. I haven't received any emails back regarding any sort of objections to those proposed exhibits. But if there aren't any sort of specific objections to those exhibits, I'd like to just be able to go ahead and introduce those. They're all documents that were filed in this case. So orders and family plans, everything that's part of the court file.
How many exhibits are there?
Let me look, Judge. I can't remember off the top of my head.
No objections, you know, they're all certified orders.
No objection, Your Honor.
No objection.
Sorry, Judge, I'm not going to click through all of them.
That's okay.
It's 7 exhibits in total, Judge.
Okay. Why don't you go ahead and list them on the record, and then I'll give, sounds like we've had no objections from 3 attorneys, but I want to give Mr. Wong the opportunity to state any objections he might have.
No objection, Your Honor. It's the court's file.
Okay. Well, let's just list them, and I'll go ahead and admit them once I have them on the record.
So petitioner's exhibit number 1, Judge, is a copy of the temporary order following the adversary hearing from October 16th, 2023 in this case. Petitioner's 2 is a copy of the family plan of service from Ms. Spence, filed in this case. Petitioner's 3 is a copy of the family plan of service from Mr. Roscoe in this case. Petitioner's 4 is a copy of the family plan of service for Mr. Bentz, filed in this case. Petitioner's 5 is a copy of the status hearing order from this case. Petitioner's 6 is a copy of the initial permanency hearing order before final order from this case. And then petitioner 7 is the copy of the permanency hearing order before final order from May 14th in this case.
All right, having heard no objections, the court will admit petitioners 1 through 7. Mr. McKesky, you may proceed.
Thank you, Judge. Judge, I'd like to call Miss Catherine Show. And are you the current permanency, or sorry, you're a permanency supervisor with Belong? Yes. Prior to becoming a permanency supervisor, what was your role with Belong?
Permanency specialist.
Okay, and were you the permanency specialist that was assigned to this case?
Yes, sir.
Okay, and how long did you serve as the permanency specialist for this case?
All the way up till June of this year.
Okay, and when did you start as the permanency specialist?
It was from the onset of the case.
Okay, so you're familiar then with the reasons the children were removed in the first place?
Yes, sir.
And do you recall what the reasons for removal were?
Yes, sir. There was ongoing domestic violence. Miles and Grace Spence had recently completed a family-based service case in July of 23 due to domestic violence. And then less than a month after it closed, law enforcement had begun getting calls for domestic violence and mental health concerns. Both parents were downplaying the incidents that had occurred. And most recently, then at that time, the parents had an altercation in the vehicle with all 4 children present. There was concern the violence was escalating and putting the children at significant risk of immediate danger or harm. And they had given time to provide a safety plan, but were failed to do so.
Okay. And following the filing of the petition, were you able to discuss the allegations with Miss Bentz and Mr. Bentz?
Yes, sir.
Okay. And did they make any sort of admissions to you regarding the allegations of domestic violence?
At that time, no, they did not. They were, I'm sorry. Miles Spence did not. He stated there were issues in the home they were working on. Grace Spence stated that it was Miles that was exhibiting domestic violence in the home.
Okay. Following the removal of the children, did you work with the parents in order to develop a family plan of service?
Yes, sir, I did.
Okay, and let's start with Miss Spence. What services were included on her family plan of service?
Random drug testing, psychological evaluation, follow all recommendations, individual counseling and following recommendations, domestic violence classes, parenting classes, attend all her parent-child visits, obtain and maintain safe and stable housing, and obtain and maintain stable employment.
With regard to random drug testing, did you ask Ms. Spence to complete random drug testing?
Yes, I did.
Okay. And throughout the course of this case, were the use of controlled substance ever a concern for you?
No, sir. While she did test positive, she did show a prescription.
Okay. Was there ever a need in the course of this case to ask Ms. Spence to complete a drug and alcohol assessment?
No, sir.
You said she also was required to complete a psychological evaluation and follow recommendations. Did Ms. Spence complete that psychological evaluation?
Yes, she did.
Okay, do you recall when she completed it?
On January 1st of 24.
And who she completed with?
She completed it with Dr. Russell Thompson's office.
And were there any specific recommendations from that psychological evaluation?
That she can attend individual therapy and medication management.
Okay. With regard to individual counseling, was Ms. Spence referred to a counselor?
Yes, she was.
And who was she referred to?
Originally, she was referred to AB counseling on November 6th of 23.
And you said originally, did she not complete services with AB counseling?
She did not. She had one session she missed due to being incarcerated, and then the other visits were canceled due to Grace having someone else in the vehicle with her. And so she was unsuccessfully discharged.
Okay, do you recall when she was unsuccessfully discharged?
It would have been on December 8th.
Following the referral for AB counseling, was she referred to someone else?
Yes, I sent a referral to Shonda Esparza on December 14th.
Okay, and did Ms. Spence complete services with Ms. Esparza?
Yes, she's completed her first session on January 2nd, and throughout my portion was engaged with her.
Okay, and you said that you handed off the case in June of 2024, is that correct?
That is correct.
Okay, so from your knowledge then, from January to June, Ms. Spence was engaged in individual counseling?
Yes, sir.
Regarding the domestic violence program, did you refer Ms. Spence to a domestic violence program?
Yes, I did.
Okay, and which domestic violence program did you refer her to?
I sent a referral to Family Violence Prevention Services on November 6th of 23.
And did you refer her to the Victims or Perpetrators program?
Perpetrators.
Okay, and did Ms. Bentz complete that program with Family Violence Prevention Services?
During my portion, no, sir. She did not complete her initial assessment until April 26th of 24. And as of June 6th, she had attended 2 sessions with 2 classes missed. I'm sorry, attended 4 sessions with 2 sessions missed.
I'm sorry, could you repeat that, Ms. Jove?
Yes, as of June 6th, she had attended 4 sessions and missed 2 sessions.
Thank you.
Ms. Schuff, were there any complications getting her registered for the domestic violence program?
Yes, sir.
Okay, and what were those complications?
So on December 15th, Grace stated that she was not an offender and would not be participating in the class. She did complete her paperwork on February 3rd of 2024, completing the paperwork to start the class. However, her first session, which would have been her initial assessment, was scheduled for March 20th, but she had to cancel due to a work conflict and was put back on the wait list for April.
Okay. And did you discuss with Miss Bentz why she needed to complete the offenders program?
Yes, sir.
Okay, why was she referred to the offenders program?
Due to the amount of domestic violence in this case from the police records, it shows the violence was coming both parties. It wasn't just Grace Bentz, it was also Miles making the comments back and forth. There was also concerns with what Scarlett Powell had stated regarding a concern for anger with her mom and reporting an incident where her mother had attempted to drown her.
And so are you aware of why Miss Bentz was making the claim then that she was the victim and not a perpetrator of domestic violence?
She stated that she never attempted to drown Scarlett and that Miles was the person that was inflicting the domestic violence on her.
Earlier you said that there was a recommendation from a psychological evaluation for Miss Bentz to complete a medication management or to engage in medication management. Did you work on those services while you were the caseworker?
During that time, Grace Bentz had continued to inform me that she was seeing a doctor for medication management. And so she had already been taking care of that portion herself.
Okay. Did she ever provide any sort of documentation to you showing that she was engaging with a doctor in medication management?
She did have to look for it real quick. But she did not provide it till after my last meeting with her at the end of May.
Okay. So she also needed to complete a parenting program, is that correct?
That is correct.
While you're the caseworker, did Ms. Bentz successfully complete a parenting program?
Yes, she did on March 20th of 24.
Okay, and who was that service provider?
That was the San Antonio Fatherhood Campaign.
With regard to visitation, how often did Ms. Bentz have visitation with the children?
For Paisley, it was 1 hour every week. For Scarlett, it rotated when I had finished, visitation had been suspended until deemed appropriate by Scarlett's therapist. They were previously, prior to that, attending their parent-child visits virtually for an hour every week.
And were there any concerns based off of those visits?
There were concerns with Scarlett's visits. And Scarlett had brought this to my attention that during the visits, if Grace got upset and didn't like anything, she would say, "I'm going to call Katie," which Scarlett thought she had done something wrong, which is what she verbalized directly to me. Grace would get upset if she's told Scarlett, "I love you," over and over again, and Scarlett wouldn't reciprocate it, or that "I miss you." And it was just very emotional. The last visit, actually, both of Scarlett and Grace ended up in tears, and Scarlett refused to continue with the visit. We had to end the visit. And that's when Scarlett told me she did not want to have contact with her mother.
Let's talk about Mr. Roscoe. Did you plan or prepare a family plan of service for him?
Yes, sir, I did.
Okay, and what was on his family plan?
Psychological evaluation and follow recommendations, individual counseling, parenting classes, follow the rules and guidelines of his supervised relief, attend all his parent-child visits, obtain and maintain safe and stable housing, and obtain and maintain stable employment.
Actually, so let's jump back real quick to Miss Bentz. Housing and employment were also part for family plan, correct?
That is correct.
And were there any concerns for Miss Bentz being able to satisfy that element of her family plan?
No, sir.
So she had appropriate housing and she was employed?
Yes, sir, that is correct.
So with regard to Mr. Roscoe's psychological evaluation, was he able to complete that?
Yes, he was.
And who did he complete it with?
He completed it with Michelle Moran.
And do you recall when he completed it?
December 1st of 23.
And were there any recommendations for services based off of that family plan?
And yes, sir. Individual counseling, random drug testing, evaluation in the home environment, employment, and parenting classes.
Okay, so the only recommendation outside of his current family plan or outside of his family plan was the drug testing element?
That is correct.
Okay. Were you able to discuss Mr. Roscoe's history regarding controlled substance use with him?
Yes, I have.
Okay, and did you have any concerns for any current substance abuse?
No, sir.
Did you send Mr. Roscoe for any sort of random drug testing?
I did not, as he was receiving the random drug testing through the supervised release.
Okay, you said he's for supervised released?
Yes, sir.
Okay, what was he unsupervised released for?
I want to say it was for wire fraud.
Were there any other recommendations from his family plan, or sorry, from his psychological evaluation?
No, sir.
Okay, with regard to individual counseling, did you refer him to individual counseling?
I did, yes, sir.
Okay, and who was he referred to?
He was originally referred to optimal counseling and to ABE counseling. However, neither of them could work out of state. So I did send a referral to him to Dr. Rachel Yates on February 6th.
And did he complete services with Dr. Yates?
He was engaged services throughout the duration of me being on there for the entire time.
Okay. Was he able to complete a parenting program?
Yes, he did.
And when did he complete that?
On October 21st of 23.
Has Mr. Roscoe been able to, prior to Scarlett's placement with him, was he able to attend visits with Scarlett?
Yes, he has had virtual visits every week. And then he also did get to have a in-person visit supervised by his parents over the Christmas holiday.
Okay. And was Scarlett placed with Mr. Roscoe while you were the caseworker?
Yes, sir.
Okay. Can you just describe for us what happened or what went into the decision by the department to place Scarlett with Mr. Roscoe?
Certainly. Mr. Roscoe had made great lengths in completing his service plan, showing that he did have a stable environment and wanted to be able to provide for his daughter. He had built his relationship up with Scarlett, and they were starting to actually cooperate more as father and daughter, and wanted to be able to provide Scarlett with stability, and so to be able to take care of her full time.
Okay. And do you recall when Scarlett was placed?
On March 13th of 24.
And did you complete the placement?
Yes, sir.
Okay. Can you just describe for us what happened whenever you placed Scarlett with Mr. Roscoe?
Certainly. At first, Scarlett was very emotional. I stayed with her to calm her down and talk with her through it. Afterwards, then had dinner, and she was relaxed. She started interacting with Daniel and appeared to be comfortable. And at the end of dinner, she told me, "I think I'm going to be happy here. I'm going to like New York." I came back the next morning. She was very happy. She was showing me her room, her playroom, and was very much in good spirits.
After you completed the placement in March, did you have any concerns for the care that she was receiving from Mr. Roscoe?
No, sir.
Okay. And did you have any concerns regarding Mr. Roscoe's housing and employment?
No, sir.
Okay. Do you believe that Mr. Roscoe was able to meet Scarlett's needs after placement?
Yes.
Okay. And do you believe that Mr. Roscoe will be able to continue to meet those needs?
Yes, I do.
Okay. Can you just explain for us why you think he'll be able to continue to complete those needs?
He's made sure that she was set up he got her set up on insurance immediately. He did go ahead and ensure that she's receiving therapy. He did work with Chosen for a period of time to help with the transition. He has continuously showed to be able to make the progress, speaking with his therapist, Dr. Rachel Yates, also involved with trying to do family therapy with Dr. Rachel Yates at that time. And he's just been very dedicated, and it seemed that has just grown. And I've been able to see just from my conversations at that time with Scarlett how their relationship has grown. And even on the trying days, Daniel has still maintained his composure and just kept going with Scarlett.
Judge, just for clarification, I don't know how long you'd like to go before lunch. I mean, it is 11:56. I'm at a good spot to take a pause for lunch if you think that that's appropriate.
My understanding is that we're going to be going through the afternoon. Is that correct?
Yes, sir.
Okay. I think it would be a good idea to give everybody a break before we do another 4-hour block or so. How long do you all need? 30 minutes? Is that enough? You need longer? Anyone?
I'm okay with 30 minutes.
What's that?
I'm okay with 30 minutes or 45 minutes, whatever the court wants to do.
I'm okay with whatever the court wants.
Let's take a half hour. It is 11:57. Let's just be back at 12:30. We'll start it back up. I'll leave this on. So mute and turn off your video if you're taking a break. Thank you. All parties excused. We're in recess.
Yes, Judge. Judge, just briefly before we continue, I was speaking with Ms. Schuff during the break, and the HR office for Belong set up 2 interviews for her to conduct for some of her open positions in her unit. I believe the first one's at 1:30, and then the second one is at 2:30. Ms. Schuff believes that she probably needs 30 minutes for each of those interviews. I don't want to waste time this afternoon, and so I would like to continue with Ms. Schuff up until about 1:15 or so, and then just ask permission to take witnesses out of order so we can at least continue on.
Is there any objection to that?
No objections.
No objection, Your Honor.
No objection.
No objection.
All right, then that'll be fine when the time comes.
Thank you, Judge.
You're welcome.
Okay, Ms. Schuff, we left off and wanted to go into the family plan for Mr. Miles Bentz. What services was included on Mr. Bentz's family plan of service?
Random drug testing, psychological evaluation, following recommendations, individual counseling, domestic violence classes, anger management, parenting classes, attend all his parent-child visits, obtain and maintain safe, stable housing, and obtain and maintain stable employment.
Okay. Okay. Did you request Mr. Bentz to complete random drug tests in the course of this case?
Yes, sir.
And did you have any concerns for ongoing substance abuse throughout the course of the case?
No, sir. While they were positive, he did provide prescriptions prior to testing.
Okay. Did Mr. Bentz complete his psychological evaluation?
Yes, he did.
Okay. And who did he complete a psychological evaluation with?
With Dr. Russell Thompson's office on November 16th of 23.
You said November 16th of 23?
Yes, sir.
And did Dr. Thompson make any sort of recommendations for additional services for Mr. Bentz?
Continue meeting with his therapist, anger management training, and continue meeting with psychiatrists and taking prescribed medication as prescribed.
Okay. And are you aware of whether or not Mr. Bentz engaged in any sort of medication management with a provider?
Yes, he did.
Okay. Did you have any concerns that Mr. Bentz wasn't following or taking his prescribed medications?
No, sir.
With regard to individual counseling, who did you refer him to?
He was actually already engaged with David Arabi.
Okay. And were you able to confirm with Mr. Arabi, Mr. Bentz's compliance with individual counseling?
Yes, he maintained compliance throughout my portion of the case.
And were you able to determine whether or not Mr. Bentz continued to see him or needed to continue to see him?
He was continuing to see him throughout my portion, stating he was actively engaged in accepting feedback, and said he was very motivated to address all behaviors.
Okay. With regard to the domestic violence program, did Mr. Bentz complete domestic violence program?
He was completing domestic violence with Family Violence Prevention Services. As of June 7th, he had attended 19 sessions with 0 absences.
So you said 19 with 0 absences?
Yes, sir.
And do you know how many weeks that program is?
24.
Okay. Did you refer Mr. Bentz to to an anger management program?
He actually had already started that before his family plan and was engaging with Dr. DeFranco.
And do you know how to spell Dr. DeFranco's name?
DeFranco.
Okay. And were you able to receive any sort of feedback from Dr. DeFranco, sorry.
Yes, sir. He reported that Miles maintained consistency in treatment and has demonstrated commitment towards his mental health and ability to navigate his responsibilities across environments, and was complying with ongoing treatment recommendations.
Okay, while you were the primary caseworker, did Mr. Bentz complete that program?
No, sir, it was still ongoing.
Okay. Did you refer Mr. Bentz to a parenting program?
Yes, sir.
And was Mr. Bentz able to complete that program?
Yes, sir. He completed it on January 24th of 2024.
What was Mr. Bentz's visitation schedule during the course of the case while you had it?
It did start originally 1 hour a week. It did increase on March 23rd to 2 hours a week. And then right at towards the end, I don't remember the specific date. I believe I want to say he had increased to 3 hours.
And were those still supervised whenever you had the case?
Yes, sir. They were supervised. I'm sorry. He had 2 hours supervised by Children Matter and 1 hour unsupervised.
Okay. And when did that start?
It was after the last court hearing, so it would have been in May.
Okay. And even though it was a short time for unsupervised visitation in May, did you have any concerns for Paisley during those unsupervised visits?
No, sir.
Okay. And then were you able to verify housing and employment for Mr. Bentz?
Yes, sir, I was.
Okay. So did you have any concerns for any of those?
No, sir.
Okay. When you were the primary caseworker, what was the permanency goal for the children?
It was family reunification.
Okay. And when there's a stated goal of family reunification, what does that generally look like?
That means the goal is to work to get the child back to one of their biological parents.
Okay. And so is it fair to say that in May of 2024, you were looking at the return of the children in family reunification with their fathers?
Yes, sir.
What were you looking at with regard to Mrs. Bentz?
At that time, we were requesting mediation to determine what her future access would be.
Well, let's go back to Mrs. Bentz for a second. When you were working with her and going through the services, were you able to gauge any sort of specific changes in Mrs. Bentz's behavior as she completed services?
No, sir, she was still highly emotional and reactive throughout my portion.
And whenever you refer parents to specific services, what is the department's expectation?
That they will engage in the service, learn from the feedback from their providers, and show a change in those behaviors that resulted in the removal of their child.
And just for clarity purposes, then your testimony is that you didn't see any sort of changes in Mrs. Bentz's behaviors whenever you handed the case off.
That is correct.
Okay. With regard to Mr. Roscoe, were you able to see changes in his behaviors?
Yes, sir.
Okay. And can you describe what those sorts of changes were?
He showed himself to be a very nurturing parent, wanting to learn as much as possible of how to help Scarlett and be able to meet her needs.
And then what about regard to Mr. Bentz?
Yes, sir. He showed to be able to maintain composure, be actively engaged in all of his services, and even during stressful situations, maintain his composure.
Okay. Pass it, Mr. Judge.
Mr. Wong?
Ms. Schoaf, you mentioned that Grace had some issues with scheduling her family violence classes, correct?
Yes, sir.
And was there a wait list for the services at some point?
She did have to get waitlisted, yes, sir. When it came to missing her appointment in March, she did have to be waitlisted.
Okay. And since she's been with the BIF classes, I know you mentioned that you only had the updated information through June. Have you been able to review the records for how many classes she's completed as of today?
No, sir.
How many classes are required to fully complete the BIF program?
24.
And would it surprise you if Grace has 8 remaining at this point?
Objection calls for speculation.
Overruled. Just reword it a little bit, Mr. Wong.
Would it be possible for Grace to have been attending classes and only have approximately 8 classes remaining out of the 25?
Objection calls for speculation.
I don't think he's asking her to speculate in the sense that the information might not be available to her. So I want to know if she's made progress. So Mr. Wong, ask it in a way to where I can find out whether or not she's making progress with this course.
And so since June, has Grace been attending the course?
I do not have access to that information.
Who would have access to that information?
The current caseworker, Kimberly Hernandez.
And is Kimberly going to be testifying today?
I believe so, yes, sir.
Okay. And so she can update the court then on the current status.
That is correct.
And then as far as the behavioral changes, which specific providers should have Grace had some behavioral changes after meeting with them?
After meeting with Ms. Shonda Esparza and with her family violence prevention services.
Okay. And oops, sorry, Judge. Give me a second. And so you mentioned the family violence prevention services, you would have expected her to have changes in behavior, correct? Where she would be able to, I guess, display responsibility for abusive behavior?
That is correct.
That she'd also be able to participate meaningfully in the groups?
Yes, sir.
That she'd be respectful of others?
That is correct.
And I assume you'd also expect that she would be resistant to strategies designed to prevent reoccurrence of the abusive behaviors?
Yes, sir.
So, Judge, may I share my screen?
You may.
You know, the object to him sharing, unless we know what it is, and it's been previously admitted.
Yeah, we need to
And Your Honor, Ms. Shove already testified that she has not had access to anything after she became a supervisor in this case, so she's not doesn't have the ability to testify to documents that were produced after she left.
Well, let's do this. Mr. Wong, ask her some questions, lay the predicate and foundation, and then we'll decide whether or not she is a sponsoring witness and whether or not we can show her.
Of course, Your Honor. And so you're familiar with the CPS case file and the Family Violence Intervention Program case notes?
While I had the case, yes, sir.
Right. And again, while you've had the case, that these notes are created on a routine basis as part of the CPS file, correct, for Ms. Benz?
Yes.
Your Honor, I'm going to object to this line of questioning. I think he's referring to notes created by an outside domestic violence source, unless I'm misunderstanding what he's referring to. But the department doesn't create notes for classes outside of the department.
Well, I want to give him the opportunity to ask her a few more questions so I can figure out what he's shooting for before I rule on anything.
And these,
Your Honor, also, I guess we also need to know if he's trying to offer anything into evidence, he has not provided any exhibits to the parties. And as you know, those needed to be provided prior to the trial.
Well, let's let him get there first. He hasn't offered anything, but I don't even know what he's trying to offer yet because he hasn't been able to lay a foundation. So let's get through that. And then when he offers it, then we can hear the objections. Go ahead.
And again, so you're familiar with the the Violence Intervention Program and the records that are kept, correct?
Yes, sir.
And the statements that I made regarding displaying responsibility for abusive behavior, showing respect for others, those are questions that are reported back to CPS, correct?
Yes, sir.
And on Ms. Bentz's file from Violence Intervention Program, it lists that they would agree that she displays responsibility for abusive behavior.
Yeah, I'm going to object to him reading from a document that's not in evidence from a third party.
Sustained. We need to get the foundation laid, and you need to offer it before we start pulling information off of it.
And again, so these documents and these notes are routinely kept by and referred from to CPS, correct?
Again, Your Honor, she's already stated that she does not have access to any of the documents after she left. And if Mr. Wong is referring to some notes, recent notes, then she wouldn't have access to those. So there's no foundation to lay because she shouldn't have access to those. She left in June, and there's another caseworker on the case now. And so I don't know where he's going with this.
Well, the question to ask would be whether or not the document that he's referring to came in before or after Ms. Schultz was the permanency specialist and then left to be a supervisor. So Ms. Schultz, Mr. Wong, ask her when this document would have come in.
Well, so Judge, Ms. Schultz, this document came in on July 7th of 2024. However, your email, is it correct to be kschultz@sjrctexas.org?
Yes, sir.
And so the document that I'm referring to would have gone to you, correct?
Your Honor, I'm going to object. He's asking about a document created by a third party. She cannot in any way authenticate a document she didn't create. It wasn't even created by the department, as is evidenced by his question.
Well, we're taking a while to get there. Mr. Wong, is this document in fact something that Ms. Schultz might have created or was part of the file when she was the permanency specialist? Or are you asking her about a document that somebody else created?
No, I'm asking, correct, Your Honor. It's a document that she received, though, from the Violence Intervention Program. She's the one, right. She's the individual who received it. It's not a part of the file.
Did she receive this after she left her role as the permanency specialist?
I just know, Your Honor, that the date of this document is July 8th, which would be after. But that's the only email that would have received this document.
Because she received the email doesn't mean it's not still hearsay. So if that's what you're looking to get in, I don't know how we're going to get there with this witness. If you're wanting to get around hearsay by saying it's a part of the file, then you have to talk to the custodian of the records, which is not her.
Correct. And again, Your Honor, I'm just trying to refer to the document in general and what was expected for Ms. Benz to show changes on. And again, I can keep going with the other question, Your Honor.
It is hearsay, Your Honor, and he hasn't expressed that it's in general. He's being very specific to what he's reading on the document. And Ms. Schoaf, as we've said numerous times, left that position in June. And so, like you said, Your Honor, even though the email may have went to her, it was not her case any longer.
Well, I'm in agreement with Ms. Pearsall and Mr. Fuller at this point, Mr. Wong. I don't think Ms. Schoaf is the sponsoring witness for this document that you're referring to.
I understand, Ron. Again, I'm not asking for it to be admitted right now. Then all I'm asking then is, Ms. Schoaf, would the behaviors that you would expect Grace to show changes of be taking responsibility for abusive behavior?
Objection. Even I don't know what he's asking. Argumentative.
It sounds to me like you're asking what type of behaviors you would expect her to see in response to whatever class she was taking. Is that what you're asking?
That's correct, Ron. And again, I'm just simply asking if Ms. Schoaf would expect Grace to show these, and it's a yes or no. And I think she's already said it was yes, that these were.
Your Honor, she already was asked and answered whether Ms. Bentz made any changes during the case when Ms. Schoaf was the caseworker. She said she did not see changes. So now to backdoor it by reading some document that Ms. Schoaf was not a part of, I object to that, Your Honor.
Well, I agree that Mr. McKeska went over that with her, but Mr. Wong has not explored it with her yet. He can still ask those questions, but I don't think you can get there by alluding to some document that hasn't been admitted into evidence yet. So just to put this to bed, I'm going to sustain any objections to any hearsay that might be elicited through this document without it being admitted. And I think we need to move on because I'm not really sure where we're going at this point.
And so the other providers that you referred Grace to, you said the psychologist. What changes were you expecting her to make from the psychologist?
The psychologist was just an evaluation that also recommends the individual therapy.
And from Grace's individual therapy, was she not going to the individual therapy?
She was still attending her individual therapy.
And so what actual changes would you have expected from individual therapy?
For her to be able to compose herself appropriately in difficult situations, to be able to address any of her mental health conditions with her therapist, to be able to discuss appropriate interventions when it comes to parenting, to be able to parent appropriately and in a calm manner, and to be able to be more resilient to negative feedback.
And I'm sorry, what was that last that you said, Ms. Schoaf?
Be more resilient when it comes to receiving information that you do not want to hear.
And so in what settings would you, can you give the court examples of when Ms. Bentz did not act accordingly?
So her last parent-child visit that I supervised, Grace became hysterical and emotional, refused to listen when I tried to end the visit with her, was upsetting her daughter and told her her daughter was making her look bad in court, and was getting very frustrated with her daughter to the point her daughter was in tears and thought her daughter told me my mother hates me.
And when specifically was this?
I will pull it up. It was in May. I will have to look up the date. I have it as May 9th.
And then after May 9th, are you aware if Grace attended any other sessions with her therapist?
She was still attending therapy, yes.
Okay. And what was the frequency of her therapy visits?
At that time to my knowledge, was once a week.
Okay. And so after that occurred, did she have any further interactions or meetings with her daughter, Scarlett?
No, sir.
And so are you able to confirm that she has not been able to make any changes since that May incident?
Objection, no personal knowledge.
Sustained.
So how is Grace supposed to make changes if she hasn't seen the child since May?
Objection, no personal knowledge.
Well, I think this question changed to more something opinion-based. And she was a caseworker May through June. So I think she can give her opinion based on that time period. So overruled.
So she can show her those during her other visits with Paisley and during her interactions in regards to her regular life and the interactions with the caseworker.
Okay. And how were her interactions with Paisley?
During my portion, her visits were going well with Paisley.
So did you have any concerns with her being appropriate around Paisley?
No, sir.
And so after May, was she appropriate with Paisley?
Objection of personal knowledge.
I think I already ruled on that. She has knowledge of how the visits went between May and June. Overall,
During my course, there were no concerns at that towards that portion.
While you were the caseworker, was it still part of the plan that Grace would have access to Paisley?
And that's what we were working on scheduling mediation for. But yes, we were
Okay.
still having visits at the time.
Sorry, what was that?
But
I'm
yes,
sorry,
we were
cut you
still
off.
having parent-child visits at the time.
And was the plan for Grace to have unsupervised visits of Paisley?
Not at that time, no, sir.
What was preventing her from having unsupervised visits at that time?
At that time, we were wanting to see she had only just begun her family violence prevention services. I wanted to see her engaged before we could start increasing. The next step would have been 2-hour visits.
And how many more visits with the family violence would she have had to conduct or complete, classes?
Your Honor, that calls for speculation on her part. It depends on how she engages in the classes, not the number of classes. It's not about checking off the boxes. It's about learning.
sustained.
What did you relay to Grace about the expectation for when she would go from 1-hour visits to 2-hour visits?
That we would wait for the results back from her family violence prevention service provider upon the following month, and then we will staff with our supervisor to discuss of increase to 2 hours a week.
And did that meeting occur?
I provided that information during the case transfer. I do not know what happened after that portion.
Okay, so your plan was to have a subsequent meeting the following month to possibly transition to longer visits.
That is correct.
Are you aware if that occurred?
I do not know, sir. I was after I had left the case.
And how was Grace in her interactions with you as a caseworker?
Grace was very emotional during most of my visits with her. My meeting with her in March, she became very distraught while we were discussing. My most successful meeting with her, where she maintained her composure and was really the only incident, was the one time in May when we met at your office.
And so is it not uncommon for a parent to be emotional when CPS is involved in the case?
I have had parents be emotional, but not to this level.
And did Grace show any other changes that you were able to observe after the May meeting with Scarlett?
No, sir.
Okay. And I know you mentioned counseling and the domestic violence classes. What other providers were you trying to see change from Grace?
It would have been also at that time she had started her anger management with her same therapist with Shonda.
And were you ever able to speak with her therapist, Chandra?
I spoke with her when we went to get the session started, which was at the end of April. And I spoke with her again right after the incident with Scarlett. I did not speak with her after that portion.
And with the anger management, was Grace receptive to the anger management with Chandra?
I had not received the notes as at that time because it had not been a month as of yet.
Okay. And prior to that, she was attending those sessions regularly with her?
To my knowledge, yes, sir.
And you mentioned that there were there drug concerns with Ms. Spence?
No, sir.
Okay. And then you also mentioned that she would have to do a medication management.
That is correct.
Are you aware if her medication was ever changed during the course of this CPS case?
She did not provide me with her prescriptions. She did provide me that she did seek believe that with Dr. Redding, if I'm recalling that exactly correct, who she was seeing for her medication management.
And do you have any reason to believe that she has not been using her medication regularly or as prescribed?
I do not know, as I don't have a copy of her prescriptions on that one.
Did you have any concerns that Grace was abusing the prescriptions?
No, sir.
And you mentioned that there was a family violence between Grace and Miles, correct?
There was, yes.
And it was from both sides of physical domestic violence?
That is correct.
What domestic violence was attributable from Miles to Grace? What occurred?
I'm going to object as to no personal knowledge.
Sustain, rephrase.
So did Miles Bentz admit to assaulting Grace Bentz?
I object as to no personal knowledge unless he admitted it to Ms. Show.
Well, let's find out if she knows or not. Overruled. Either Ms. Show, you either know or you don't know.
He never disclosed anything directly to me, no, sir.
Did Grace disclose any domestic violence to you?
Yes, sir.
What did she disclose?
Your Honor, and I'm going to object to that unless it's a statement against herself. It's hearsay.
Well, it's a statement by a party opponent.
Right, but if it's a statement against another party, that's a self-serving statement. That doesn't qualify under that exception. If she admitted to the domestic violence she committed, then that qualifies.
It's part of the reports, Your Honor. The statements that both parties have made are compiled in Ms. Show's reports.
You're asking her a question that's based on information that's already in the report?
It's correct, Your Honor. These are in the reports.
Oh, it's in the report. We've all seen it.
Well, what report is he referring to, Your Honor?
Which report are you referring to?
So it's the initial report for the September 15th incident.
Are you talking about the affidavit?
I don't think I think it's part of that. That's included, correct?
Your Honor, then that's the wrong witness.
The affidavit is based on the just the sworn allegations of the investigator. Ms. Shope did work on this case, but she was not the investigator.
I can move on, Your Honor.
Okay.
And so, Ms. Shope, the concerns with Miles Bentz, what were they?
There was concerns that he had engaged in domestic violence with Grace Bentz.
And were you provided with any documentation to support the domestic violence claims?
Investigations was provided with documentation.
Okay, and were you able to review any of the documentation as the supervisor?
As the caseworker, yes, sir.
Okay, and the documentation reviewed, what did it contain?
Objection, hearsay.
Sustained. I'm not sure where we're going with this one.
So, Ms. Shope, you reviewed documentation. What documentation did you review that gave you the impression that there was domestic violence committed by Miles Bentz?
Objection, hearsay, and speculation.
Rephrase.
Why are you of the opinion that Miles Bentz committed acts of domestic violence against Grace Bentz?
Objection, Your Honor. She already testified she has no personal knowledge of that. And you already ruled on that as well.
It's different, Your Honor. This is based on what she's seen, and it's her opinion of, and in her mind of what has occurred based on what she has reviewed in the case.
She has testified she has seen nothing. He's trying to get in inadmissible hearsay. If he wants to bring in some documents, he's an attorney. He knows how to share documents he chose not to share before this trial.
He asked her about her opinion, and we have a verifiable period of time where she was the caseworker and she worked with these parties. So if you're asking her about her opinion based on her experience working with Mr. Bentz, then I don't think that is objectionable at this point for her to offer her opinion on that. And he's asking her why. So overruled.
It was based off of information from the removal affidavit. for the reason for removal.
And what was that?
One
Your
of
Honor,
the-
that's been asked and answered from the very beginning.
He hasn't asked it. She hasn't answered it from him. Asked and answered it doesn't apply globally. It's party to party. I'll let him have a little latitude on it, but not much, Mr. Wong. We need to move on. Overrule.
During that incident for the last removal in the vehicle, it was stated that Grace Spence had tried to grab the steering wheel to swerve the vehicle into an 18-wheeler, in which Miles Spence then did punch Grace Spence in the face to prevent some.
Were there other incidents that you investigated regarding Miles Spence assaulting Grace Spence?
Your Honor, I'd object. Ms. Schoaf is not an investigator. She didn't investigate any incidents. She's the legal worker in this case. What was the legal worker?
Saying, rephrase.
Are you aware of any other incidents of physical domestic violence against Grace Spence committed by Miles Spence?
What did you say?
I didn't hear that.
I would object to hearsay and lack of personal knowledge.
Ask your question again, because it garbled up on me.
Are you aware of any other domestic violence incidents between Miles Spence against Grace Spence, committed by Miles Spence against Grace Spence?
Overruled. He's asking her if she's aware of it, not whether it happened or what the details were. She's either aware or she's not. Overruled.
Not through direct knowledge.
What knowledge do you have?
From information that Grace Spence has reported.
Okay. And have you reviewed information from Miles Spence where he has stated that he would lie and make false reports?
Your Honor, I'd object to facts not into evidence.
Well, I think he's trying to get him there. He's asking her if she's aware of it. I don't think he's trying to make a connection to anything that's not in evidence right now. He's just asking her a question. Overruled.
Your Honor, but he can't ask the question by allegedly misquoting what somebody else said.
Well, I don't even think we're to that point yet, but rephrase, Mr. Wong. I mean, here's the thing. We're going to be here so much longer than we have to be if everything that comes out of Mr. Wong's mouth is objectionable. So, Mr. Wong, you need to watch the questions you're asking. And before you all object to it, you need to make sure that you have a legal objection to something that he's asking and not something that he might ask. Otherwise, we're going to be here all day. Go ahead, Mr. Wong.
Are you aware of Miles Spence telling CPS that he would make lies against Grace Spence?
No, sir.
When Scarlett was moved to New York, how many different counselors or therapists did she work with?
She had a therapist in Houston who helped with the transition to going to New York. And then she worked with family therapy with Dr. Yates, plus the therapist that was in New York that they were getting set up.
And was Grace involved with meeting any of those therapists?
No, sir.
Was Grace ever set up to have any sessions with the therapist?
No, sir.
Is there a reason why she would not be able to communicate with the therapist?
At that time, we were trying to get Scarlett leveled in addressing the behaviors, the trauma she had experienced. Also, which was the time in Houston and then with Dr. Yates. The goal was eventually, once Scarlett settled down, we were going to work with trying to get towards doing visits through family therapy for Miss Spence. When I was transferring over the case, Scarlett was just starting her initial intake with the in-person therapist in New York.
So the plan was for Grace and Scarlett to still have communication and work on therapy amongst themselves.
To have visits through therapy if recommended by the therapist.
And when you were on the case, did that ever change to where Grace was going to be cut out completely?
No, so that was the last thing we had stated.
And are you aware of any events that occurred after that date that would create a situation where Grace now would have no access?
No, sir.
And with Paisley, was there a situation where you believed that Grace would not be a part of Paisley's life once this case concluded?
That would have determined the totality of the entire case.
While you were involved in the case, was that your opinion that Grace would not have access to Paisley?
It was still unsure at the point that we were working towards mediation to determine that.
And hypothetically, if Grace completed the classes that she needed to finish, would she have access to Paisley?
It would have been the
I'm sorry, Your Honor, I'd object to that. Calls for speculation on her part. I know it's a hypothetical, but she hasn't been on the case since June.
I would agree, sustained.
And Judge, it is 1:25. I know the chef has that interview at 1:30. So if we could hit the pause button on her testimony.
We can. There were no objections, so I will excuse Ms. Schoaf. We'll recess her testimony at this time. Who do you want to call next?
Judge, I'll call Mr. Hernandez.
All right, Ms. Schoaf, whenever you're done, come on back. Get in the waiting room and I'll let everybody know, okay?
Thank you, Judge.
All right, thank you. And remember, don't discuss the case with anybody else while you're gone. All right. Ms. Hernandez.
Can I ask if we take like a 60-second recess?
Sure.
Thank you.
Thank you.
Judge. Mr. Hernandez, can you please state your name?
Yes, Kimberly Hernandez.
And how are you currently employed?
I'm a permanency specialist with Belong.
Okay. And are you the current permanency specialist for this case?
Yes.
And when did you become the primary caseworker?
Mid-June of this year.
And as part of your duties as the current permanency specialist, have you reviewed the case file and the things that happened prior to you becoming the current permanency specialist?
Yes, I did.
Okay. And have you taken up the responsibility of ensuring the parent's compliance with their family plans of service?
Yes.
Okay. So let's start with Mrs. Bentz. And whenever you took up the case based off of my notes, she was engaged in individual counseling with Ms. Shonda Esparza. Is that correct?
Yes.
And have you had the opportunity to follow up and gauge Ms. Bentz's compliance with individual counseling?
Yes, I have.
Okay. And what sort of progress has Ms. Bentz made for or with her individual counseling?
Yes, her therapist states that she's met with her biweekly since June, and that she is continuing to do an anger management through her sessions, and has been progressing at meeting those goals that they've established in sessions.
Okay. Have there been any major concerns with Ms. Bentz not attending individual counseling?
No, not since I've been on the case.
Okay. Have you been able to discuss the treatment goals and those sorts of things with Mrs. Bentz?
Not with Ms. Bentz, no. I've spoken with the therapist.
Okay. What is your understanding of what those treatment goals are?
Yes, I can I pull them up? I'm sorry.
Well, just what's your understanding of them?
Okay, so working through her triggers, and what would trigger her, that's what the main thing is through their anger management. She has been, her therapist did state that she has been, her mental health seems to be better since the OnStart.
Okay. Has Ms. Esparza successfully dismissed Ms. Bentz from individual counseling?
No, she hasn't.
And what is your understanding of what Ms. Bentz needs to continue to address, or what's been unaddressed in her individual counseling?
From my conversation with the therapist, they are still working through her anger management goals. The last notes I received was that they were going to be out for the next 90 days.
Can you explain that for me?
That she would still be receiving services with Ms. Esparza for the next 90 days.
Okay, so there's a recommendation for continued therapy for the next 3 months.
Yes.
And was there any specific issues that need to be addressed in those sessions that you're aware of?
Not that I'm aware of. I know Ms. Esparza did state that one of her big concerns is that Ms. Spence tends to get into relationships quickly with men, and that it was disclosed during a session that she is currently pregnant and residing with someone.
Have you been able to address that with Ms. Spence?
Not in depth, no, sir.
With regard to her domestic violence program, where is she? So that is a terrible question. With regard to domestic violence, what is your understanding of how many classes she's completed?
The last report I received was the July progress report, and she had completed 11 classes and still needed 13.
Have you received any reports for the month of August?
No, I haven't.
During the period that you've had the case, has Ms. Bentz missed classes?
No, she hasn't.
Have you been able to discuss what Ms. Bentz is learning through domestic violence with her?
No, I haven't.
And is Ms. Bentz only required to complete the domestic violence program for perpetrators in this case?
Yes.
Okay. Are there any other services, ongoing services for Ms. Bentz at this time?
Aside from therapy and domestic violence?
Yes. Okay. Have you had an opportunity to visit Ms. Bentz's home?
Yes, I have.
Were there any concerns with the home environment?
No, there weren't.
Okay, with regard to visitation, what is Ms. Bentz's current visitation schedule?
Currently, she has 1 hour supervised visits with Paisley weekly, and visitation with Scarlett has not occurred.
Okay. Why does Ms. Bentz still only have 1 hour of supervised visitation per week with Paisley, given the current stage of the case?
When the case transferred to me in June, it was discussed that if she were to be progressing to 2 hours supervised visitation, that we would need to see progress in her domestic violence classes. The report that we had received in May showed that she was showing resistance to the group sessions that she was having. So that did not occur at that time.
Okay. And have there been any additional discussions since that time frame to increase visitation?
No, there hasn't.
You said visits with Scarlett were suspended?
Yes.
With regard to Mr. Roscoe, are there any ongoing services for him at this time?
Just continued therapy with Dr. Rachel Yates.
And how is he doing in that therapy?
He's doing well. Dr. Yates hasn't reported any concerns.
Okay, and is that just individual therapy, or is it also family therapy with Scarlett?
It had also been family therapy with Scarlett. Dr. Yates wanted her to be established with a therapist in person in New York because she wasn't doing very well with the Zoom sessions.
Okay. And has that therapy for Scarlett been set up?
Yes, it has.
And have you had an opportunity to get any sort of progress reports on that family therapy?
It's individual therapy that she's receiving in New York, but no,
Okay.
I haven't received progress notes yet from that therapist.
Okay. Have you had a chance to evaluate how Scarlett's doing in Mr. Roscoe's home?
Yes, I have.
Okay, and what is your assessment of how she's doing?
She's doing well there. She is comfortable. She seems very bonded with Mr. Roscoe.
Have you had a chance to visit the home?
Yes, I have.
Okay. Did you have any concerns for the home?
No, I didn't.
And how long ago did you have that in-home visit?
I visited in June and July, and prior to me taking over the case as the primary worker, I also visited in April and May as well.
Okay. Is Mr. Roscoe currently meeting all Scarlett's needs?
Yes, he is.
Do you have any concerns for his ability to meet her needs in the future?
No, I don't.
Okay. Does Mr. Roscoe have any other services that are ongoing at this time?
No, not at this time.
And then with regard to Mr. Bentz, does he have any ongoing services?
Yes, he is continuing to engage in his individual therapy and anger management, as well as medication management with his psychiatrist.
Okay. How is he doing in individual therapy?
He's doing very well. I've received progress notes for this month and last month from the therapist saying that he is committed to sessions and maintaining composure and handling life stressors.
Okay. Have there been any recommendations, or were there any recommendations from his therapist?
No, there weren't.
Okay. Has the therapist made any sort of recommendations of how long Mr. Bentz should continue to engage in therapy?
The last note that I had said that there were sessions scheduled until the end of August. I'm not sure if there have been any more for September scheduled.
Okay. With regard to the anger management program, how is Mr. Bentz doing that program?
He's doing very well.
Have you been able to get any updates regarding recommendations from that program?
I spoke with the therapist that's doing anger management, Dr. DeFranco. He stated that Miles is continuing to do very well in that therapy, and he doesn't have any concerns currently for him.
Okay. Is there a specified number of sessions for anger management, or is it just an ongoing service?
My understanding it's ongoing.
Okay. And then how's Mr. Bentz doing with regard to his medication management?
He's doing well. He has sent me his prescriptions from when he met with the therapist, I'm sorry, the psychiatrist this past month.
Okay. Do you have any concerns that he's not complying with that service?
No, I don't.
Okay. As part of your responsibilities, do you meet with the parents often to discuss the current state of the case?
Yes.
Okay. When's the last time you met with Mrs. Bentz?
I met with her last month. I'm sorry, last week.
Okay. And have you been able to gauge whether or not mom is making behavioral changes based off of what she's learning in her classes?
That has been my only meeting with Miss Bentz. But based on that visit and conversation with her therapist, she is progressing.
Okay. Since you've had the case since June of 2024, why is it that you only met with mom once and that was last week?
I attempted to visit with Miss Bentz in July with her attorney. That visit was canceled whenever I was on my way, I believe, due to a medical emergency.
Okay. So you personally haven't been able to really draw any conclusions regarding changes in behavior for Mrs. Bentz in this case then?
Correct.
Okay. What about with Mr. Roscoe? Have you been able to make determinations with regard to him?
I have met with Mr. Roscoe multiple times, I believe for the past 4 months, and I don't have any concerns with Scarlett being placed with him or his progress in his services.
Okay. And then finally for Mr. Bentz, have you been able to ascertain whether or not he's made any behavioral changes as a result of his services?
Yes, each progress note that I've received from his therapies have stated that he's made behavioral changes.
Okay. What about your personal observations?
Each time I've met with Mr. Bentz, he's been composed and respectful to me. Based from the beginning of the case till now, I wouldn't be able to gauge that.
Okay. Pass what instruction?
Mr. Wong?
Ms. Hernandez, you stated that the reason Paisley hasn't had increased, or Grace hasn't had increased visit time with Paisley is because she wasn't participating in the group sessions with domestic violence. Is that correct?
There was a progress note from the domestic violence classes that stated she was showing resistance to the group therapy.
And showing resistance in what way?
I'm not sure as to the links of that. That is what was in the progress note.
And these progress notes, these are notes that, sorry, you can finish your response. I apologize.
Oh, I was just saying at the time of transfer.
Okay. And then the progress note, you said that was in the May report that you receive?
Correct.
And do you receive reports on a monthly basis, like May, June, July, etc.?
Yes.
And you've had a chance to review all of those reports?
Yes, I have.
And so in those reports, it states that she's not
Objection to hearsay.
Sustained. Let's get there another way.
And when you are reviewing the progress reports, do you agree, or does Grace's behavior in groups, has it improved or not improved?
Objection to personal knowledge.
Mr. Wong, let's lay the predicate for what she knows about the reports in the file.
The family violence reports, how do you receive those?
They're emailed to me once a month.
And is this are these reports something that you review and you receive on a regular basis?
Monthly, yes.
And these reports, they comprise how you make your determination on what to do on the CPS case?
Yes, they're a part of it.
And as being a part of it, you review what they say, correct?
Yes.
And you've reviewed these reports and notes?
Yes, I have.
And you've only been reviewing them since May, correct?
Correct.
And again, these reports are something that are regularly made by domestic violence program and submitted to you for review so you can make recommendations.
I'm sorry, can you repeat that?
You use these reports when you determine what to recommend.
Yes, they are part of it.
And for for participation in the groups, what are the 5 categories that are graded?
I'm not sure. I would have to pull up a progress note.
Can I refresh the witness's recollection, Judge? I can pull up a progress report.
No, there's no way to do that on Zoom. It's a hearsay court statement.
She can send it. She can review it herself if she has the notes in front of her, or I can email them to her.
If she's trying to refresh her recollection and it's the same report that everybody's entitled to as part of the file, he's laid a foundation. Is that the report you're going to use, Ms. Hernandez?
Judge, I don't think it is. Our discovery was provided to us on May 23rd. He's referring to something that occurred since then that wouldn't have come to anybody but mom's attorney. So the rest of us, well, at least I for sure hasn't seen it. I don't know about the child's attorney. I can't speak for her.
If you want to ask about it, Mr. Wong, for recollection to be refreshed and use a document, it's got to be a document everybody else can see. Do you want to send it to everybody else to use it?
I can send it to everybody else, Judge, or I can just share my screen and everyone can look at it. Whether we send it through email, I can just share it right now. They can all see it.
Well, if you send it through email, everybody gets an opportunity to review it and decide if they want to object to it. So why don't you send it to everybody, let everybody see it, and we'll come back at 2 o'clock. It's 1:53. That's 7 minutes.
Can I get everyone's email just so I can make one group?
Put it in the chat. Put your email in the chat, please. We'll be in recess.